Our next speaker is Professor Henry Gabriel, who will be speaking with us today by audio link. Professor Gabriel is professor of law at Lund University. He has, with more than 20 years of dedicated service to the development of uniform commercial law. He's a life member of the Uniform Law Commission. He was the reporter for the revisions of those sales and lease provisions of the Uniform Commercial Code. He's a member of the UNIDROIT Governing Council, and of course a member of the 2010 Principles Working Group. He currently serves as a U.S. delegate to UNCITRAL with a focus on electronic commerce and transport documents. Professor Gabriel will discuss some of the common law approaches that have influenced the development of the principles to the point where they were adopted, notwithstanding their relative unfamiliarity to civil law traditions. Henry, are you there?
I am indeed, Richard.
Oh, great. You have a bit more. Thanks.
Thank you. I'm in here three very sort of interesting questions, and that's the question of how one might, at least initially, how one might get out from under an agreement by mere notice to the other party. And we start with Article 3.2.11, notice of avoidance. And as the principles point out, the right for a party to avoid the contract is exercised by notice to the other party. It's got to be reasonable notice. Notice has to be received. But the terms, the basis for avoiding the contract or a contract under the principles are very similar to the common law basis for avoiding contracts, things such as mistake, fraud, threat, and so forth. And these are questions that go to the validity of the contract. So the principles are consistent with the common law in that when you avoid the contract for purposes of claiming that there's a question of validity there, we treat the contract as never having existed. So we go back to a point where it's as if nothing happened, and you have to go back to ground zero. Now, the reason the common law has always taken the position that notice alone would provide for avoidance is because it allows the party who's voiding out the contract to get out of the contract as quick as possible and not have to perform any aspects or put forth any more resources to a contract that wouldn't be enforced anyway. There is one distinction that one should note, though, between the common law or the common law cases and the principles. The principles take the position that mutual restitution would be applied when a contract is avoided. And that makes perfect sense. We treat it as if there is no contract, yet parties on both sides may have received some benefit. And in order to put the parties back to the position they would have been in, the mutual restitution would be the proper result. The problem we have in the common law cases, certainly in the American cases, is the courts have been absolutely inconsistent with that. That restitution is often awarded, but often courts have awarded strictly reliance damages and not restitution. And in some categories of cases, for example, a contract avoided because one of the parties was a minor, no remedy whatsoever is often allowed, so that the minor actually gets to keep the benefit of what has been received thus far and doesn't have to give restitution. So that's one functional distinction I think we need to note, is that the common law remedial structure is inconsistent for no particular reason other than it's historically inconsistent. A second article that we want to look at is Article 732, and that's notice of termination of a contract. And one point I think we have to start off with is the concept of termination. The common law cases and the UCC have been very inconsistent with what that word means. For example, the Uniform Commercial Code takes the position that one terminates a contract for reasons other than a breach, for example, by operation of law or by consent of the parties. But if we use the word termination in its broad sense, that the parties are suspending performance and do not have to complete performance because there has been a breach and a breach of substantial nature, then in that case, in that situation, the principles are very consistent with the common law, and that is that where there has been what we would call a material breach in the common law, which is roughly equivalent to a fundamental non-performance under the principles, the parties get to suspend any obligation to continue to perform, and the contract ends at that point. Now, one thing that we have to keep in mind is that both within the common law cases as well as within the principles, once the party decides to pull the plug and terminate the contract on the basis of a severe breach, a fundamental non-performance under the principles, or a material breach under the common law, the party does take the risk that at a later time, a court or arbitration panel might determine that the breach was not as significant as the non-breaching party thought it was, in which case the act of terminating the agreement, in fact, would have constituted a breach by the non-breaching party. So that's always a risk. Irrespective of that, it would seem that the rule is eminently sensible, and that is that once it's clear that the other party has breached in a fundamental, significant way, it just doesn't make any sense to require the non-breaching party to put forth any additional resources with the uncertain future of where the contract would go as a whole. A third section we want to look at is Article 722, which is basically specific performance. And the principles take a fairly strong, if I can, and it's always somewhat of a gross generalization to say that civil law gives a higher preference to specific performance than the common law. That certainly has historically been the case, but I think that we see a lot more merging in recent years. But taking that as a basis, the principles overall take a fairly strong position toward allowing specific performance in a way that would not generally be allowed as easily in the common law. But there is an exception. And the principles state very clearly you get specific performance unless you come within one of the exceptions. And one of the exceptions is where there is clearly an alternative source of performance, where a party can, for example, go out and get replacement goods, replacement services. In that case, you would not be entitled to specific performance. Now, that should be fairly familiar to common law lawyers. It's a particular application of the principle of mitigation, which basically says that if you can reasonably avoid having to put someone out, then you really haven't suffered the harm. And so you can easily mitigate your damages here. But to a large extent, it's the only practical result that parties would want. If one party is refusing to perform already, the only sensible practical commercial result in most circumstances is to try to go and get replacement performance anyway. Because how do you enforce specific performance? If the party refuses to perform, you have to go somehow get court judgment and force them to perform. And that's a lengthy and expensive process. It's usually a lot quicker and easier to get the replacement performance and then just go and sue for damages later. So as a practical result, this rule seems to make a lot of sense from a commercial standpoint. Anyway, that's sort of basic points that I want to make on these three provisions. It's very hard to encapsulate this in about 10 minutes. I think I just did.